Yes, now I'm requesting CEO sir to kindly start this webinar session, please. Over to you, sir.
Thank you very much. And thank you very much, Mr. Aditya Singh, for sparing this valuable time with us. Uh, as a series, I would like to inform all the audience and the speaker that Skill Council for Green Jobs has been organizing a series of webinars under the banner of Azadi ke Amrit Mahotsav. In fact, we started somewhere in September 2021 with this effort, and today's seminar or the webinar is the 95th in the series. We have been covering various aspects of renewable energy, waste management, green hydrogen has been one of our focus. So probably Mr. Aditya would be the first speaker, I would say, to cover the most important aspect of regulations in the renewable energy sector. In fact, one of the most difficult is, topics to be covered in such a short time, and I'm sure we all will benefit from the experience and the coverage of Mr. Aditya. I would now request Mr. PB Singh to introduce the speaker and take the webinar forward.
Thank you, CEO sir. Thank you very much for welcoming the speaker and audience. Good afternoon, everyone. I'll welcome you all to the 95th series of the webinar. Skill Council of Green Job is organizing a series of webinars to celebrate Azadi ka Amrit Mahotsav as a part of India's celebration of 75 years of independence. In this series, SCGJ is inviting eminent and learned speakers in different sectors on sustainable development, renewable energy, and waste management, so as to deepen the understanding of the recent development in these sectors. The first in the series was launched on 24 September 2025. Today we have Mr. Aditya Kumar Singh, a very experienced learned distinguished speaker who will be sharing his expertise and experience on regulatory issues in renewable energy sector. I would like to share a brief profile with all of you. Mr. Aditya Kumar Singh completed Masters of Law in Finance from Institute for Law and Finance, Frankfurt, Germany. Mr. Aditya Singh is a partner at a Denton Link Legal, New Delhi, specializing in the regulatory and compliance area of the project energy and infrastructure practice. He has been advising energy companies on power purchase, transmission services, and competitive bidding, and has also advised clients for their investment in the energy, ports, and SCGJ sectors. He has represented various government distribution companies, private generating companies, captive power producers, and open access consumers generators in preceding setting commercial and regulatory matters across various fora, including the Supreme Court, APTEL, and various regulatory commissions. Few of recent assignment of Aditya ji, respected represented power developers before Andhra Pradesh High Court in PPA termination dispute. Represented power developers before Punjab State Electricity Regulatory Commission against shutdown notice issued by Punjab State Power Corporation Limited. Represented open access developer before Haryana Electricity Regulatory Commission, challenging imposition of reliability charges. Representing captive power consumer before Maharashtra Electricity Regulatory Commission against attempt the Maharashtra distribution companies to remove captive status, etc. Mr. Aditya Singh is an author with the Economic Times and Marcon Indias, has a strong interest in academies and has played an instrumental role in finalizing of the course on energy law of various law and technology schools. Now I would like to request Mr. Aditya Kumar Singh to start the presentation. Over to you, Mr. Singh.
Thank you, Still for India. Thank you, Mr. Singh. Am I audible?
Yes, yes.
So I will start sharing if I'll be allowed.
Yes, sir, yes, sir. You're allowed.
I'm allowed. So I said. Rohit, you have my slides, if you can share it.
Okay.
Because I cannot see where is that option coming.
Not an issue. Yes. Is this visible, sir?
Yeah, it's visible.
Yes.
I'm intending to cover regulatory issues in renewable energy sector. It's a vast topic and I will not be able to do justice if I will try to cover all issues in given time frame. So I will consider it as a basic. So I will try to cover some basic aspect of regulatory issues. Rohit, if you can move on the next slide. So I will start with giving the overview. Then I will come on conflicts of jurisdiction. Then I will come on conversion of bid into award. Rohit, the next slide. Rohit, can you give me the access to just
Sir, you are having the access, sir. Yeah, if you may share your slide from your end, then you may change the slide according.
okay. No, but will I be able to access this slide only?
No, sir.
No.
No.
So then I need to say again
Yes.
and again to you.
Yes, and you just have
Then
to
I will
say next,
yes.
sir. Okay.
Okay.
Sure.
Then I will come on tariff and termination of PPA next. Next. Before I start on dealing with the current framework, it is relevant to note how this electricity law came in the life. In 1879, the word electricity was introduced in India. It was in the Kolkata. Reorganization or a solution or a pattern governing the given event. So in 1879, when it was introduced, law also followed the electric events very fast. The first legislation dealing with the electricity came in 1887. So as I told you, just 8 to 9 years back, electricity was introduced. So there was no concept of private generation. There was no concept of private participation. So basically this piece of legislation was intending to cover the safety aspect of the electricity. 1903, it was a large framework where they gave certain aspect about generation distribution also, because as I told you in 1887 it was just a concept of electricity. So what is the safety mechanism, how the electricity will flow, all those aspects were there in 1887. But 1903, I can say in the true manner, the first electricity legislation of India. But there were certain flaws in 1903 legislation that was got removed in 1910. You know that there will always be a statute and then there rule, because inherent limitation in the act. Of that act will not be, there has to be a rule. So introduced. Next. Next.
Rohit, slide, change the slide. Rohit,
I am very sorry, sir. Due to the technical glitch, I just log out. I'm so sorry for that. You may continue, sir.
So allow me, I will share it. Have you allowed me?
Yes, yes, yes.
So this is my slide?
Yes, sir. Yes, sir. Is this your slide, sir?
Okay. When India got independence, there was a conflict that it will be a social state or a capitalist state. What our policy maker at that relevant point of time decided, it will be hybrid. So if it will be hybrid, so majority of the assets will be under the state control. If majority of the state assets will be under state control, then there was a debate on what is the role of. There was also dispute who will having control over different assets, whether it will be state or a central. What we decided that electricity should go under concurrent list. The concurrent list for a non-lawyer, it means both central and state will have a power to frame laws. So till that we follow the same pattern that central also makes laws, state also has a right to make law. And if there's a conflict, then the central law will prevail. Till 1990, it was mostly state controlled sector. There are very few era which changed everything, where liberalization started happening, started reform in our various aspects of life. One of the important aspect was what World Bank said, that you have to go for liberalization. It means you have to go for private sector reform. If you go for private sector reform, it means you have to invite private participation in the electricity industry. But state government didn't want to lose control over this sector because its electricity is one of the essential commodity. So what they did, they said that, look, we'll allow the private participation, but the tariff, which is the most crucial part of any electricity industry, will be fixed by the state or the central government. This system continued till 1998. In 1998, electricity regulatory commissions were introduced, and the control of tariff was moved from central to state electricity. The state got at the same time. Then in 2003, Electricity Act came. Electricity Act came. Major region be aspect of the electricity, that is generation, transmission, trading, and stakeholders like it introduced, that is the finding the electricity. Let's suppose region of India, and you have one distribution licensee operating in your region. That distribution licensee has the obligation to supply power to you, but you want that there should I can take power from someone else, that is a private developer. That right was also introduced in the why this open access. One of the major challenges in energy sector is which court to approach if there is a conflict. There are two major judicial forum available, that is the Central Electricity Commission, another is the State Electricity Commission. Both are court of first instance. Court of first instance is if you have a dispute with a distribution licensee or any licensee, you will approach to this forum. If you are located in one state and supplying power to that state, then rule is very clear that you go to the State Electricity Commission. Conflict comes supplying power to Bihar, and Energy Watchdog judgment to approach the committee in tariff. So let's suppose if you are a line to Assam and Bihar, and the 4 is for Assam, INR 4 for Bihar, it as a composite scheme and saying that you approach to the Central Commission. In Energy Watchdog, I will give some background of Energy Watchdog judgment. Energy Watchdog judgment came because there was some coal pricing issue. There were changes in Indonesian laws in concerning coal. Few private developers approached for change in law. Change in law is a mechanism that if you have entered into a power purchase agreement with a distribution licensee, generally and ordinarily, your tariff is fixed. PPA only gives you a provision that if there is change in law and due to that change in law, there are any changes in the price, you can approach to the commission and ask for the compensation. One of the prime dispute was which commission to choose. The DISCOMs argued that the generators should go each state commission where they are supplying power and asked for change in law. The generators argued it's a composite scheme because we are supplying to two states. DISCOMs opposed, saying no, composite scheme will only if the tariff would have been the same. Supreme Court said composite scheme does not require uniformity of the tariff. Composite scheme will be if you are supplying power to two or more states. This dispute will further be analyzed in subsequent discussion. I will analyze that. Just for Energy Watchdog, keep in mind that composite scheme is there if you are supplying to two or more states. This was Energy Watchdog judgment. when these Jawaharlal Nehru solar missions were introduced, various solar power developers started establishing their power plant. In 2017, GST was introduced and imposed on solar power modules. Various generators relying on the energy watchdog judgment started approaching Central Commission. DISCOMs again said that, look, for approaching a Central Commission, there has to be a composite scheme. And the composite scheme means if you are supplying power to two or more states. So what Andhra Pradesh and Telangana said, that you are my generator because those generators also approached who came out with a good argument. Composite scheme does not necessarily state. They said that read Jawaharlal Nehru solar scheme. And there is a provision for 10% supply to other states. So it was a real opposite, and one of the ground was that SECI cannot approach CERC. SECI has to approach MERC. SECI relied on energy watchdog judgment. SECI relied on CERC, saying that I am a central intermediary, and if I am involved, it has to be before Central Commission. Maharashtra composite scheme will only when you will be acting like a generating company and power is being appointed you. So MSEDCL had appointed. This tender was for the so it's being supplied to a rule of composite scheme. The jurisdiction will be Maharashtra. CRC post this judgment also started diluting its own stand. And in SECI versus Sapurji Palonji, what the same type of dispute what was before MERC, UPPCL had appointed SECI to float a tender for it was a floating solar, and two developers were shortlisted. One was Renew, another was Sapurji Palonji, that is Rihan floating solar. Dispute went to CERC. CERC said, look, even if SECI is involved in this tender or bidding management, but since it was conceptualized for one state and power is also being supplied to one state, CERC has no role to play. It will be only UPERC which will adjudicate the dispute. Now I will come on the another important aspect, that is tariff. The word tariff has nowhere been defined. So if you read the Electricity Act 2003, which is the parent legislation, it does not define the word tariff. Tariff has been defined in various Supreme Court judgments. So basically, it's a consideration for the electricity supply. What Supreme Court says, that will go by the dictionary meaning. So tariff is just a rate card, whatever you are supplying and whatever you are being paid. Tariff can be determined only by two ways, and two relevant sections of Electricity Act is Section 62, Section 63. Section 62 speaks about determination of the tariff. So there will be one relevant Electricity Regulatory Commission which will analyze your project cost and placing reliance on the relevant tariff regulation will give rate of return and will determine. This may be, there may be two types again in 62 also. One will be the project specific determination, where the developers will be required to submit all the relevant cost, and the another will be generic tariff determination. Generic tariff determination was in fashion from last so many years. After 63 being introduced, or bidding guidelines have come, I will not say it has been stopped, but very few 62 you will see. So generic tariff order simply means that every year placing reliance on the normative figures, the Electricity Commission will determine the tariff. That is 62. 63 speaks about two essential components. One is there has to be a bidding guidelines, and the second important aspect is the process should be transparent. So 63 is basically a competitive bidding process where few interested developers will participate, quote their tariff, then there will be expert committee. Expert committee will give a recommendation. Post recommendation, DISCOM will declare bidder. Post declaration of bidder, there can be a final or discovered tariff will go before the Electricity Commission, which will in 2010 and 11 there was a dispute that what is the role of Electricity Commission, whether it will be act like a post office that you come, DISCOM comes, submit the discovered, no role to play. They will not apply their mind, and they will just adopt as it is. Because if you read section 63, it uses the word that the commission shall adopt the tariff discovered in the bidding process. So SR power was a dispute where this where successful bidder was SR, UPPCL had floated, NPCL had floated the tender, that is Noida Power, and filed discovered bid before UPRC for adoption. When this bid was pending for approval, another bidder, Athena Power, expressed its interest to supply power to NPCL less than whatever was discovered. NPCL filed one IA before UPRC saying that don't consider SR bid, consider Athena because this is lesser than what has been quoted by SR. When this matter came before the appellate tribunal looked, you do not have negotiate once the tariff has been discovered and placed before the commission. So the role of distribution licensee will be limited till the tariff is not discovered. Tariff is discovered post it has been submitted for adoption, then they cannot interfere in the matter. So appellate tribunal said that the SR bid is valid and the contract should be awarded to SR. After that, one minute. Before this SR, I wanted to discuss this regulatory power of the commission, MP powered rating. This is also an interesting judgment on the role of Electricity Regulatory Commission. Bid was floated and Lanco was the successful bidder. Lanco discovered price was submitted before the MP Commission, but Lanco expressed its inability to continue. Two other developers' bid was submitted before the MP Commission. MP Commission refused to adopt, said that I cannot because the successful bidder was Lanco, not these two subsequent bidders. In this judgment, what appellate tribunal said that, look, all were participating in the bid process. If one has pulled out, next two has a right to be appointed. Although this judgment has been diluted, I will discuss with you few more judgments, then it will be very clear, because this judgment which came in MP power, then you have SR, then you have a Sunny. This is BACS dispute. We discussed two disputes. One is declared successful up till took U-turn. BACS invited bid. Sunny Solar was one of the successful bidders. There are various other successful bidders also. LOI was issued to them. BACS filed that bid for approval. On the first hearing, BACS in its affidavit appreciated developers' effort for reducing the tariff, and they pleaded it was in their prayer that please adopt this tariff because we have complied with all prerequisite conditions of section 63, read with bidding guidelines. That is, it's a transparent process. We complied with the terms of the bidding guidelines. When this bidding process, when this bidding was not being adopted by ERC, there was something happened in down south in Andhra Pradesh. Developers started quoting tariff of around 4, and this tariff was around 5.5, 5.6. BACS filed one IA before DRC saying that prices are going down. On the basis of this, we want to withdraw. Delhi Electricity Commission, without informing successful bidders, allowed withdrawal. Sunny Solar filed an leave to appeal before appellate tribunal, saying that we are the affected parties. Minimum, the Electricity Commission should have heard us before deciding our fate. It was a procedural argument. The second arguments were on the substantive aspect. The substantive aspect was that I am the successful bidder. Your case laws says once the tariff is being discovered and the bidding process is transparent and the bid process has followed the bidding guidelines, no one has role to interfere in my right, not Electricity Commission, nor this distribution company. Appellate tribunal surprisingly ignored its own orders given in MP Power Trading and SR Power, said, look, we have read the bid documents. They have a right to cancel this bidding at any point of time. Although the appellate tribunal should have cognizant of the fact that even if someone has right to cancel, that right is not arbitrary right. That is always a regulated right. That is always subject to Article 14, that is reasonable, fair, appellate tribunal also said bids of other states or the tariff of other states were going down, so it will be in the consumer interest. So one new aspect appellate tribunal in Sunny Solar judgment said that if consumers are going to be benefited, the electricity commissions have right to interfere. The third argument of the appellate tribunal was that the generators have no vested right. Generators were not entered into any definitive agreement. There was only a letter of award or letter of intent, and it does not create any vested right on the generators. After this judgment, industry started seeing frequent cancellation of bid document. The DISCOMs used to float tenders, and that process takes around 6 to 8 months. And when from the date of bid submission till the date of signing a PPA, it's a time gap, and other states used to get lower tariff, citing that this DISCOMs started canceling the tender, started not honoring LOIs. The one of the recent example was Dholera bid, where GUVNL said that, look, tariff is not viable. And one of the relevant aspect is this bid was discovered after third attempt, because Dholera geographical location is not such where you will get the viable tariff. So 2 unsuccessful attempt. In third, when few developers shown interest, GUVNL surprisingly said, look, this tariff is not viable. The same mistake which DISCOMs did in Sunny Solar was repeated here. There was no notice to successful bidders, and GERC allowed withdrawal. Matter went till appellate tribunal. Appellate tribunal matter was pending for a year. Both sides wanted to negotiate. Recently, appellate tribunal said, look, the minimum the before passing serial order, they could have heard the interested parties. So on that ground, this matter has been remanded back to GRC. This again, as I am telling you, that all states started following, even UP followed it. In UP NEDA bid of bid, there was no document which was issued in favor of any developers. There was no LOI, no LOA. Matter kept pending for a year. Surprisingly, UP NEDA cancelled the tender, saying that you all developers did not renew the security amount. No one contested, so that's again only for the tender. Any right or not. Supreme Court, not in the electricity sector, but port bidding. One developer was successful. That developer had got LOI in its favor. It was a LOA, but LOI is same. And for that matter, name of the agreement has no relevance. You need to see what is written in the contract. That's what Aptel has also said. It was argued by Mr. Shanti Bhushan that whatever is being written, that will be governing factor for determining the relationship. LOA was issued. Bombay High Court said that the moment you have issued LOA and they have gone through the terms of the LOA, they said that it's a binding instrument. Matter went till Supreme Court. Supreme Court also said that, look, I am not going to go in that debate whether there was any binding instrument or not. There was one LOA. And if you read the terms of the LOA, both parties had agreed to be bound by the terms of the LOA. Once parties have agreed to be bound by the terms of the contract, then there is no scope for judicial interference. Then other side cannot just cite certain give certain this principle will
Aditya sir, your voice is breaking.
equally applicable on the renewable energy.
Aditya ji, your
Hello.
voice is breaking.
Can you hear me now, sir?
Yeah, right now is okay.
Okay, sir.
Sir, your slide is not visible. Requesting you to kindly share your slide again, sir. Yes. Yes, sir.
No.
Am I audible?
Yes, sir. Yes, sir. You're audible, sir.
Sorry, it's just network problem I am facing.
Sir, your slide is not visible, sir.
Now it's visible?
No, from my side, it is not visible. PV Singh, sir, is this visible to you?
No, I'm not.
No, sir, it is not visible, sir. Aditya, sir. Yes, sir. It is visible now, sir. You may
Just finish it. So basically, as I told you that there are two types of tariff. One is section 62, another is section 63. One of the major dispute is once one developer has entered into a PPA and the tariff is fixed for the project life, that is 25 or 20 years, can it be revised? There are two important judgments. First, there are in section 62, the landmark judgment is Tarini. Tarini says it can be revised if there are change in circumstances post signing of the document. So the change in the Tarini was there was a hydropower plant, and in the document which was signed, it was said that the nearest substation is 4 kilometers. When developer started working on the project, they realized that the nearest substation is not 4, it's more than 100. So the cost increased to 10 crores. When they approached Electricity Commission said, look, PPA has been signed. I am not going to allow any revision in the tariff. Supreme Court said, no, if there is a change in circumstances, it can be changed. But when it comes to the section 63, Supreme Court is very conservative. Recently, it was a Tata Power, it was a Jayaprakash Power project in Uttar Pradesh Power Corp, in UP. and JP was facing certain financial difficulties, so it was taken over by Tata Power. In this deal, the lenders agreed to reduce certain financial burdens from the company, so there was just some gain. UP Electricity Commission said that since there is some gain in the process, why don't you share that gain with the consumer? So basically, you reduce the tariff. Tata argued that, look, it's a 63. I cannot change you cannot ask me to reduce the tariff. Appellate tribunal said if it's a section 63 tariff, it cannot be changed. Just for the benefit of the audience, this issue will also be decided and settled by the Supreme Court. Supreme Court is hearing Andhra Pradesh appeals, where 63 projects, the solar projects, are out of this dispute, but 62 is still pending, where Supreme Court has to take a call that whether tariff can be revised or not. So that's it from my side, Mr. Singh.
Okay, thank you, sir, for the very good presentation. Rohit, can you give permission to all the audience for any question?
Yes, sir. Sir, I already gave the right. Now, if any audience wants to ask anything from Aditya, sir, then you may kindly unmute yourself and ask your question, please.
For better connectivity,
Okay.
can I just switch off my video, because there is some network issue here, with permission?
Sure, sir. Sure, sir. Sure, sir.
Yeah, any questions from audience to the speaker? We are with us, Dr. Debajit Palit. Sir, any question?
No, not from my side.
Okay. Taneja sir?
Yes.
Sir, any question?
Yeah, Aditya, I want to ask Aditya, these disputes what he has narrated in his presentation, and the original thinking that states can have their own state regulatory commissions, and the center has got CERC. Both should work in a matter that they should get they should align with each other. That is one thing. Secondly,
Sir, sorry, I can you just repeat? I couldn't hear it. Can you just repeat? Sorry for that.
Yeah, Aditya, this is Taneja.
I can recognize you, sir. Yes, sir. Tell me.
Yeah. Now, the thing is that you have told that when the regulatory commissions were installed, that state regulatory commission has got the rights to act upon independently or on the guidelines of the CS. That is understood. Now, presently, the CERC, whatsoever, most of the regulatory or notifications, etc., they are not being accepted by the states. They are again going and changing their versions of this thing to suit the state-specific problems. Now, how this is killing the renewable energy industry in many ways.
Understood, sir. So that's why if you read the act, that's also says they'll be guided, but guided does not mean binding. So one has to start telling them guided at least means that you should give you a reason why you are deviating. So guided also does not mean that they can choose not to follow. It simply means they are not bound by that, but it also means if they are deviating from if they are taking some different view from Central Commission, they have to scientifically suggest that how this state specific requirements are and how it's different. So that litigation one has to start. The developers have to start saying that, look, you have a right, because it's not a binding, you also know, sir. They are required to be guided. So that litigation one has to start. So, and that's what we are doing. You are also doing at some level. But yes, I understand that's not very successful.
Right. Another thing is all these things are creating problems for the whole of the renewable industry, whether it's a wind or solar. Now, what is your idea how this can be solved, that at least the directives from center are accepted by the states? Like, for example, in MSME sector, center gave directions to all the states that they should go ahead with this sector, which has been a prominent sector in wind till 2011, that they should maybe by bidding or by the other process or tariff FIT process, they should come out with the 25 megawatt
Yes.
this thing. Now, it was in 2018. Now, but none of the states have agreed to, because of their own problems of revenue loss or whatsoever it is, except Gujarat, which is now in the recent policy they have
Yes.
proposed.
Yes.
Now,
Hello.
how states can be told to go ahead with this thing? Do you think that renewable energy law will work on this aspect?
So, sir, as you know that there is a series of judgments from the Supreme Court which says that court cannot issue direction for the policy decision of the state. Second, as I told you, electricity is a concurrent subject. So both have a right and power. Having said that, if central government is issuing certain directions, state is bound to follow it, but that's the prolonged litigation we have recently seen in one of the state where it was a clear direction from the central. Courts are not very reluctant, citing this law that I cannot issue direction for issuance of any policy directive. So I feel there should be change in the Electricity Act itself rather than issuing these random directions. If the central government is so determined to support the sector, there should be some overhaul of this Electricity Act. Just issuing certain directions, those will not be changed anything. And if you go to the High Court, I have seen at least 2 High Courts. High Courts are very clear that no, we are not going to give any direction to this state.
Yeah, that is what I think. In 2015, when center issued a draft of Renewable Energy Act, it was with the intention that this act will be enforced, and all the states will be bound to do that accordingly. Now, this has not taken shape, but I think in the absence of Renewable Energy Act, although in the 2020 or 21 they had put some lines of a Renewable Energy Act or something, but that also didn't materialize. So what should be done in your views that this Renewable Energy Act can come into force or can be done? Hello?
Can you hear me, sir?
Yeah.
As I told you that the changes in the Electricity Act is required, not issuance of any direction. Because there is an old Delhi High Court judgment also, which had said about a lot of things about 107. Recently in this Fatehgarh Badla judgment also, up till it said that 107, 108, all those will not work. So that matter is also pending before the Supreme Court. So directions, there are negative judgments as on date. So better that Electricity Act should be changed to give more power to central if we want.
That's right. Anyway,
so Mr. Singh, I will take leave.
Yeah.
I am somewhere else.
I
Sorry for
remember,
that. It's all trouble from my side.
Remember is the meeting. I remember
Yes,
your
yes,
meeting time. Finally, first I would like to thank you, Mr. Aditya Kumar Singh, for accepting our invitation for the presentation. Thank you, sir, for very good presentation. It's very informative and knowledgeable. Hope all the participants are get benefited. Once again, thank you very much, sir. Now I would like to thank all the participants for their valuable presence and support. Thank you very much, all of you. Thank you, sir. Thank you very much.
Thank you.
Thank you, sir.